Okay, so tonight, the first thing I want to do is I want to give you some comments about your last two assignments, the official reprimand letter and the case study, the first case study. And because there were some things that I want to just make sure that I underscore for you. To start with, overall, the reprimand letters were well written and would pass legal scrutiny. And one of the things you need to realize is that, remember, we have this pesky little thing about open records, open public records. And so therefore, what you write and put into a file could be open to the public. And so, and it also might get challenged legally, particularly if there's some issues that can pop up. The one thing that I wanted to point out to you, though, is that a few of you made the mention of written warning, or you said warning. And I want to make sure that you understand there's a significant difference between a warning and an official reprimand, okay? The official reprimand is just that. We are officially reprimanding an employee for something that is a violation, particularly of the policy or handbook. And a written, of course, you go through the various progressive stages, and you have an oral warning, which happens often, I suppose. But then there's a written warning. Now, the written warning does not go into the individual's file. You keep it for your own purposes. And while I'm on that, I might as well mention this, because I don't think I've mentioned this. So there's such a, even with the Open Records Act, or Public Records Act, there is a sole possession file. Now, what a sole possession file means is that no one else sees this but you. So for an example, if you were keeping records of a student's misbehaviors and no one else saw it, then that would be a sole possession file, and so no one could request that file. So it's kind of good to know that along the line. So, you know, some of you referenced warning, so I would strongly suggest you go back and take that out of there, because you don't want to confuse people. This is an official reprimand, okay? The second thing, and I didn't, you know, I know that I didn't give you maybe the clearest of directions with this, because we were kind of in between sessions, but this letter should be written as a business letter, meaning with an inside address and an outside address. And if you haven't studied business letters since you're in the third grade, understand, and oftentimes the address, your address, can be on the letterhead. That's fine. Then the address to the individual goes in the letter. I was a little bit kind of disappointed or surprised, and it was okay, but I'd never, quite frankly, I gave you, I think it was an Indeed website on suggestions for writing this. And what they did was they had your address, and then they had a space, they had the date, and then they had the other address. That's okay, but if you can envision, a letterhead would be more professional looking. And of course, you know, that's part of it as well. You want to present yourself professionally. Here's the thing that I really want you to also hear. Well, I'm going to ask you the question. Let's see how well you remember your third grade business writing. Following on a business letter, following a greeting, dear da-da-da, what is the punctuation mark that's used?
Is it a comma?
Nope. Those are friendly letters.
Period.
It's a colon.
Ah, okay.
You know, one of the things that I've learned over the years is that we kind of have gotten away from maybe even teaching letter writing, which can be a fault as far as I'm concerned, particularly if you are going to be writing business letters. But you should always use a colon instead of a comma. But I didn't mark you down for that because I knew that probably most of you didn't realize that. And so I thought, well, I'll just explain it here. Another thing, in writing these type of letters that are going to be under possible legal scrutiny, you want to be as succinct and to the point with crisp sentences as possible. So succinct and to the point. You don't want to meander around. Each paragraph should have a clear purpose, and I was glad that Indeed talked about that because they did that. And for, once again, for legal reasons, you want to be as specific as possible. And you guys did a very good job of identifying the mistakes that the individual had done that you witnessed that brought you to the point of an oral or an official reprimand. And that's the other thing, you know, you don't want to get to an official, I mean, an official reprimand is a big deal. And so therefore, you know, if a person's late, and this was good because you addressed it in your letters, if a person's late one time, you know, you don't write them official. You might warn them, okay? It should be a repeating kinds of things that gets into that official reprimand situation. The other thing, and once again, this is something that we want to make sure that you clearly understand. With official reprimands and stricter job actions. Now, when I say job actions, what I mean is suspensions. What I mean is obviously terminations would be the strictest. Strict job actions, you always want to underscore that, always meet with the employee in a face-to-face meeting. Always. Because first of all, you have to give them due process. You have to give them the opportunity to explain themselves. And having written a number of these, you know, you don't present the letter to them right out of the gate. You bring them in the office. You say, we need to talk about a situation. You lay out the situation orally, and you give them a chance to clarify. And maybe after the clarification, you know, I've had a baby that's sick. Well, gee, you know, I'm sorry, but that's pretty cruel if we have to, you know, if we are following the policy to the nth degree when we have this legitimate. Now, understand that people are going to tell you whatever they'll tell you to get themselves out of trouble, but you give them a chance to tell their side of the story, so to speak, and then from there you give them the official reprimand letter. You have it. It's always good to have it pre-written, although if you have to throw it away, that's fine and dandy. Things change, but that makes it more. You are showing authority when you do that. Okay, and that's very, very important as well.
Does it have to be signed?
What's that?
Does it have to be signed from both for it to be like?
Yes, yeah,
you?
it's a great question. And the answer is it would be best to be signed by both and dated. Now, the one thing I'll get into this when we get into student rights, but let's say that an employee will not sign it. Don't get into a screaming match or a power match. You just ask the secretary or somebody to come in and witness the letter. Okay, witness that they were given opportunities to share, et cetera, et cetera. So that's a absolutely great question. Are any of you guys in unions? I don't think many of you guys are. Oh, you are. Oh, interesting. Okay. I bet you. And one of the Noels, is this your first year in a union?
It's my second. I was at a private school before that didn't have it.
Okay.
This is my second year now at a public
Okay.
union.
And it's different, isn't it?
Oh, yeah.
Being in a union is different. And so the point that I want to make here is you want to be very knowledgeable of that negotiated agreement, because that negotiated agreement might say that that individual has the opportunity to be represented at the meeting with maybe the union president or somebody. And so, once again, this is legal action. So if you didn't do that, all of a sudden, your opportunity to reprimand this person has gone out the window because you violated that negotiated agreement. Okay. So the other thing that I want to mention to you is that as you are creating things like this, maybe even suspension letters, when I taught computers for school administrators, I had my students, even though they all could do word processing, I had them write things such as recommendation letters, suspension letters, et cetera, because you need practice in this. So you want to make sure that you save or store whatever you've written. You might find that you even get better as you send your second one or your third one or whatever. So you can copy and paste. It makes it so it's a little bit faster for you to copy and paste to do that. But of course, make sure that you really read it afterward, because nothing worse than copy and paste and have the wrong name in there. So anyway, this will save you time for sure. And the other thing that I want to make sure that I tell you, because it's important that you hear this, as a beginning assistant principal or principal, you should not have to go through legal issues alone. What I mean by that is if you find that you're in a legal issue, it would be very worthwhile to contact your supervisor before you take action to get their advice, their wisdom, et cetera, et cetera. So when I became a principal, I was at a vocational school, and sadly, we were suspending probably 2 students a day. So sad. Yeah, 2 students a day. My superintendent knew that I was new at doing this. He required me to call him, explain the situation before I even brought the student in to talk with him. So he was making sure that I was on good legal grounds before we moved forward. So my advice is feel very comfortable to call that supervisor and say, hey, here's what I've got going on. What do you think? And get their advice. Okay. In the meantime, the other thing that it does for you is it provides backup. All of a sudden, instead of that supervisor getting this suspension appeal out of the blue, they have a bit of an idea. Now, as you get more practiced in doing these kinds of things, you obviously won't have to do it that often. But you do not have to go through some of these legal issues completely on your own. Questions on the official reprimand letter? Okay. So now we're going to talk about the case study. And overall, you did fine with the case study. Okay. I urge you to look at my responses. Okay. And with the legal issue, you can be very, very specific. The legal issue is freedom of speech. The legal issue is due process. The legal issue, and you didn't necessarily get, and you did fine, but I'm trying to help you get through the weeds a little bit. Okay. So for the next one. So, just be very specific, such as that. With the citations, recognize that I'm primarily asking you about key statutes and landmark U.S. Supreme Court cases, because those are the most important. We can get into the weeds with all this stuff, as we've already spoken about, but I don't want you to get into the weeds. And so therefore, I just want you to know those key statutes and those usually U.S. landmark U.S. Supreme Court cases, and you'll do fine. It's okay if you cite Michigan law and a few of you did, that's fine. No worries about that. You don't need to do that on average, okay? You won't need to do that because once again, I'm looking at the big picture again. And here's what I expect. When you are faced with a legal situation in real life, what I want to have happen is a bell go off. Oh my God, this is search issue. I got to remember, and in real life, you don't necessarily have to remember the case, okay? But you might have to, with regard to student searches, you'll find out later, you have to know the procedure that you must use in order to not violate that student's searching rights, okay? So we want that bell to go off, and note that you should feel comfortable in sharing that situation with your supervisor again. Feel comfortable in sharing with them to avoid big errors. And one of the things that my Franciscan students love to hear me say, because I said it quite frankly, quite often, I guess, is you ain't got a problem, a legal problem, until you got a legal problem. Now, what I mean by that is that you could violate a teacher's rights. But if nobody calls you on it, or nobody questions you, well, you just got away with it. So you don't have a problem. Now, I don't want you to do that, but just realize you ain't got a problem until you have a problem. Okay. So questions about the case study. And I know that this was your first attempt at this. I really appreciated you understood the format. You did a nice job with the format. You overlooked a few of those landmark cases, and they are extremely, First Amendment's one thing. The Pickering case interprets it, and so they're a public concern. Therefore, that's something that you need to be aware of. Okay. Questions on the cases?
I don't have any questions, but I wanted to thank you for all of the notes that you give us because it really helps me to understand where you're coming from so that I know what to do next time.
Well, good. I'm glad to hear that. And this gets me into the next thing. Typically in my class, I always offer opportunities for bonus points, because what I don't want to have happen is, in a couple of instances, this case study, you didn't score quite as good as you wanted to. Okay. And I'm going to give you an opportunity to recoup some of those lost points with a useful assignment. So I just added this, after I graded the case study, I went, oh gosh, I forgot to put in the bonus, 10 points bonus that I'll put in here. And here is the bonus activity. You are to write a letter of recommendation. And letters of recommendation, that's another activity that you do often. You might even do that as a teacher, quite frankly. And so therefore, and there's kind of like the official reprimand letter. This could be, usually not, but it could be considered a legal document. Okay. And so this letter of recommendation, I'm going to have you write on me as your adjunct professor. And so we'll give you the particulars about how to put those together, give you some examples, and so that'll be an opportunity for you to make up some points that maybe you've lost otherwise. Okay. And that letter is not going to, you won't find it. Well, I think I've already got it, so you could probably see it. It's not, but it's under module 14, and module 14 is later, of course, and it's a lighter workload, so it kind of fits in. It won't be due until the end of the class, December 11th. So you got some time on that. Okay. After this quiz, we go into module 8, and module 8 is religion in public schools. Now, quite frankly, I could probably teach you that in 30 minutes, okay? And it is not a very lengthy module. And I'm quite astonished that the author makes it like the second or third chapter, because it's with legal issues, particularly religion in public schools, it has been ferreted out. It has been ferreted out what to do and what you can't do for years. And so therefore it doesn't come up very often in what you're doing. And module 9 is on school safety. Now that is kind of an important issue. Not kind of, it's an important issue. Although we are just going to give you some background about school safety. Now, one of the activities that you're going to do is you're going to do an analysis of your school's safety plan. And hopefully you can find that and kind of work through my checklist is, yes, we got this, yes, we got that. Here's my recommendations. And I would suggest that if you get an opportunity to serve on a school safety committee, for example, do it, because this will give you added experience with that particular issue. As I mentioned, these modules are less intense. And then we get into student rights. Of course, that's a biggie. And we get into special education rights, another biggie. We get into student discipline, student attendance. So we're starting to make that transition from the employee and their rights to the students and their rights. Some things cross over, some things don't. So that's kind of the direction that we're heading. Questions on where we're heading and issues that you have and want me to respond to as far as the class is concerned? Okay, so I'm taking another turn here. Leadership has advised me to let you know that Tervia has replaced Portfolium as the repository for key assessments. I see that like 4 of you have already gotten in there, got your information set up. So for this class, the 2 case studies are your key assessments. And so what you'll put in there is you will put in your rubric that you received from me that will be used as the key assessments. And once again, you should activate that link as soon as possible. If you, they ask you to have a code, I guess they sent a code to you via email a while back. And so that's where we are with that, okay? And I'm learning it. I've spent time trolling around on it myself, and I don't know that I feel overwhelmingly competent in it yet, but by the time the class is over, we'll hope that we will be competent in it, okay?
Did you say that they sent us a code in an email?
That's what the director said, yes.
I didn't receive
It
a
was a
code, and when
while-
I tried to go on there, it required a code, so I don't know.
Right.
Code
Yeah.
was received on my end.
Yeah, so, and basically it was
I
said
don't have one either.
it was sent a while back, whatever that means, okay?
Right.
Yeah, so maybe I hope that that the memos is a Tereva code or Tervera code, because then you could do a search that way. But it should be a search, or it should be a memo from the director, I think. Okay,
Oh.
okay. Questions about that?
So how do we go about, I didn't get an email either, so I don't have a code, so I wasn't able to upload anything to that new site. I'm guessing.
Okay, I was gonna, if you just put code on your email, sorry to cut you off, but
Okay,
it was sent, if it does work, but it was sent April.
Mhm,
Oh,
April
wow.
16th, I just
Wow.
found it.
Yeah,
That,
that helped.
that's kind of interesting. It was
Okay.
6 months ago or whatever,
Yeah.
longer than that ago.
Gotta find it on your like email, hopefully.
Yeah, okay. So anyway, we were advised to let you know those kinds of things, okay? So now let's get into the content for the next quiz. We're talking about modules 5, 6, and 7, okay? The first objective is recognize labor laws such as labor standards, collective bargaining, and workers' compensation. And the first one is the National Labor Relations Act. Can someone tell me what that law is in general?
It makes it clear that it is the policy of the United States to encourage collective bargaining by protecting workers' full freedom of association.
Boom, she studied. Yes, and in the public sector. I always like to bring this up, not part of the lessons or anything, but President John F. Kennedy signed an executive order. I can't remember what year that was, in the early 60s, that allowed public school or public employees to get into labor unions. And so that kind of opened the door for public employees and schools in particular. Okay. Michigan Rights of Public Employees. Can you remember what that particular law was about in general?
I found it.
Okay.
An act to prohibit strikes by certain public employees, to provide review from disciplinary action, and to provide for mediation of grievances.
Yes. And this took place in 1947. By the way, the National Labor Relations Act took place in 1935. And so this is kind of a mirror law to the National Labor Relations Act, although you said the main word, no strikes for public employees in Michigan, okay? And that gets into the next one, the Michigan Collective Bargaining in Public Sector, MCL 423.215. And basically, school districts and public actors have an opportunity to get into a union. Now, I don't get into the weeds, but there's a specific way for a school district to become a collective bargaining unit. And I say that primarily for Catholic school students. Now, I don't want to raise a revolt, but they have the right to organize if they so choose. And there are some in these United States. Pittsburgh is probably the strongest. The Pittsburgh Diocese, that particular union is extraordinarily strong. And of course, you know, what it does is raise salaries and raise the working, or maybe improve working conditions. So, and of course, there's some specifics in that law. You've already hit the main one. It's illegal to strike in Michigan. You can collectively bargain, but you may not strike. We'll get into this repeal of the right to work here in a moment, but well, might as well go ahead and say it. And this just happened within the past few years in Michigan. Michigan chose to pass a law that says if you have a union and an individual fails to pay union dues, they may be fired. That's pretty harsh. I haven't seen that in too many states. I was really quite surprised to see that, quite frankly. By the way, in Ohio, you can strike. We had to deal with that on occasions. And of course, in the meantime, we had to work through the remediation. When you go to impasse, now you have to work into other kinds of situations. The Michigan Workers' Disability Compensation Law, pretty self-explanatory.
The right to the recovery of benefits shall be the employee's exclusive remedy.
Yes, so if you get hurt, you have the right, if you get hurt on the job, you have the right to receive disability compensation and workers' compensation, okay? One of the more interesting situations that I got into with regard to this was I had a custodian who was sharpening blades for a mower, and a piece of metal hit him in the eye. Of course, there's strict processes you have to go through in order to get into the workers' compensation pool, so to speak. And we accomplished that, and he went to the doctor, and later it was discovered that this was not, he had a sty in his eye. It was not the cause of the metal. He had a sty in his eye, which then changed the whole picture, because instead of going through workers' comp, he had to go through his the district insurance, which was okay. I mean, didn't bother us or him either. Okay, so I always know that with regard to Catholic school students, they tend not to have a lot of knowledge about collective bargaining, and some of this terminology is extremely new to them. Okay, so explain the differences between an agency shop, a closed shop, and a union shop.
An agency shop is a place of employment where union members pay union dues and other workers pay service fees to the union.
Yes, and of course, in Ohio, we don't have that right to work law. So therefore, if a person chose not to pay their dues, there was a union, they chose not to pay their dues, they aren't going to get fired. Okay, as opposed to Michigan, I mean, like I said, I haven't seen that in too many states, quite frankly. I was quite surprised when I saw that, but that's the law.
Wow.
Okay, so let's talk about
So
oh, go ahead.
which one were you just talking about right now?
That was an agency shop.
The agency?
Agency shop. Okay. So now let's get
They're
into
not required to be with the agency. They're not required to be part of the union.
shop has a negotiated agreement.
Okay.
but-
And so I guess the closed one is the one that you have to be part of a union to be hired?
Yes.
Okay. Okay.
And so that's a closed shop. A closed shop is it requires you to be a union member as a condition of employment. So you have to be there. And so all of those kinds of things are typically written into the negotiated agreement. Okay. So you might want to look at the negotiated agreement to see what kind of shop you are. Okay. However, with that Michigan law, you have to pay your dues. There's just no getting around it. Okay. And of course, that would leave us with a union shop, and requires employees to join a union. You're required to join a union. They're required to pay dues to the union as a condition of retaining their employment. So all Michigan schools would have union shops. Okay. Understanding the new, yes, go ahead.
I have a question. So the union shop requires to join the union,
Yes.
but
And
then we
yeah, you have to join the union, and you have to pay the dues.
So what's the difference between it and the agency shop?
Okay, the agency shop is one in which there is a union, but you're not required to join the union.
Okay, and then the closed one, you can't be hired unless you join the union. So it's similar to a union shop.
Yes.
Okay.
Yes,
Okay.
okay. Understand the nuances of collective bargaining. And so I'm going to use some terms here. And once again, I always know that when working with Catholic school students in general, these are pretty foreign to them. They aren't familiar with it. I'll ask the Nawals, have you been through a negotiations yet in your school
So last year they did.
last year?
Yeah.
Okay.
That was the year that they went through it, and yeah.
Yeah. And, you know, in general, when a school district goes through negotiations, it's kind of a tense time. There's tension between management and the staff. And that's kind of unfortunate, but that's what happens. So one of the terms we want to make sure you hear is good faith bargaining. When you start negotiations, the expectation is to have good faith bargaining. What that means is that both sides are trying to get to a settlement. Okay, both sides are trying to get to a settlement. The next is scope of bargaining. And there's mandatory topics and there's permissive topics. Mandatory topics, as you might guess, are salaries, benefits. Those are two of the if you have a union, you've got to discuss those two topics. Okay, at some point in time.
That last one you said faith bargaining, and what was the second one?
Okay, mandatory topics or issues and permissive issues. A permissive issue means that you're not obligated to bargain it. Now, that doesn't mean that one side or the other is going to bring this up in negotiations, but you aren't mandatorily required to bargain it. One of the topics that is often discussed in collective and as a permissive topic is class size. And unions have been trying very hard to get a class size identified for elementary schools, for kindergartners, et cetera, and typically management doesn't want that. And you can probably imagine why. And so you'd have to look to see in your union contracts whether or not class size. And once it's been bargained and decided, it then becomes mandatory bargaining. So once you have bargained a permissive issue, future negotiations can include that topic. Okay. So another issue that's permissive or not permissive, that is mandatory, is sick leave. The number of sick leave that you can accumulate, for example, that's typically a mandatory item. So when one side or the other stops their good faith bargaining, that means they're not bargaining anymore. The school district is now at impasse. What that means is one side has stopped bargaining in good faith. And there are a number of ways that you can resolve an impasse. Okay. And those are arbitration, fact-finding, and mediation. I actually should have told you mediation first. Mediation, so in my district, we came to impasse, and the person who was working with us actually put management in one room and put the union members in another room, and he would go back and forth and say, they want this. What do you think? Yada, yada, yada. That's mediation. There's absolutely no legal cause to complete the negotiations under mediation. you may not come to resolve, but what's gonna happen is you're gonna pop up to the next resolution. And the next resolution could be fact-finding. And with fact-finding, it's just what it explains. There is an examination of the facts. For example, let's say that, I'll use my own example. We're negotiating with the union, and we were in pretty good shape financially. It was near the end of my days as a superintendent, and we were fairly healthy financially. And they knew it. I mean, because you have to be pretty upfront with your resources. And so when there was a we didn't go to fact finding, we resolved it through mediation. But had we gone through fact finding, there would have been a pointing out of, school, you've got this much money. The teachers want 4% increase. You can afford this. So why aren't you giving it to them? Basically, that's fact finding. On the other hand, so I would always do a complete review of our negotiations, and we then submitted the initial proposal. And I discovered that we had 260 days of accumulated sick leave. There was no other school district that had that many accumulated sick leave days. What that meant is that a teacher could skip the whole year and get paid. And we had teachers who were doing that. They would get pregnant, they would go on leave, and they would then use that to get paid. And it was costing us big money. And so therefore, I tried to ratchet that down. Sometimes it's hard to do that, but we made our case as to, look, we're out here in the 99th percentile of accumulated sick leave. We want to get at least to the 70 percentile. Okay, then there's arbitration. And arbitration means this. There's going to be basically, and usually the person who is doing this, working with the school district, is an employee that is an employee of the National Labor Relations Board. And so they are working on proposals that they think can bring the two parties together. And upon their conclusion with arbitration, you have to accept that third party's decision. So those are the resolutions when you hit impasse, okay? So, once again, I always know that Catholic school students tend not to know much about collective bargaining. And I at least want to give you some generals that you generally understand that, okay? So now we're going into module 6 and distinguish between procedural due process, substantive due process, property interest, and liberty interest. So let's take the easiest one first. What do you think procedural due process is? Go ahead, Noel.
Following a specific procedure.
Yes, following a specific.
Am I getting that right?
You have to do A, then B, then C, and D. That's the one that's the most easiest to explain. Substantive due process is a little less, is harder to explain. That is a principle. It's a principle that allows courts to protect certain fundamental rights from government interference. Okay, and although it's not mentioned in the Constitution, but it represents fairness. Substantive due process is being fair. Procedural due process is just cut and dry. You do X, Y, and Z. And once again, I always found it so interesting when a new board member came on board, they thought they were going to fire the English teacher because their student had a run-in with them. And when they found out, oh, sorry about that, but there are procedures we must follow. And the first one is we're going to look at the evaluation of the teacher. Okay, so then these kind of go together. Property interest. Property interest. Can someone tell me what property interest is? Well, property interest is just that. The property that a person is entitled to as an employee. So if an individual has tenure, they have property interest as far as salary is concerned for a long time. Therefore, in order to take disciplinary action against them, we have to rise to a higher level of due process as opposed to the individual who's maybe in the first year of their contract. Okay, and tenured teachers have a continued property interest. And of course, property interest would also be benefits as well as salary. Okay, then liberty interest, liberty. These are freedoms that are not named in the Constitution. For example, you have the liberty to move from one residence to another residence. You have the ability to do that. And that would be a liberty interest. Okay, so things such as that, individual freedoms, basically. Okay, so now we're going to get into the disciplinary aspects of this particular module. Differentiate between non-renewal and termination. First of all, let's do that first. What's the difference between a non-renewal and a termination?
So non-renewal, you wouldn't get your contract will not be renewed.
Exactly.
Termination, you're leaving right, right when you get terminated.
You're
and
being
there's-
fired. Basically, you're being fired. Okay. And so there's a difference between those two. And if you ever find yourself being non-renewed, I mean, I know it's traumatic, but you shouldn't, it doesn't necessarily have anything to do with you nor your employment. It might mean that the school district didn't have money and they had to non-renew you, as opposed to a person who gets terminated. It's a whole different ballgame. Okay, so now let's take this and talk about non-renewal and termination with probationary teachers versus tenured teachers. Who has the strongest case for due process? Probationary teacher or tenured?
Tenured teacher,
Tenured.
tenured.
Absolutely tenured teachers. They have the strongest case, and we have to provide them with lots of procedures, actually. And of course, school districts in Michigan now grant newly certified teachers tenure after they have completed 4 years of probationary service in an appropriate position and have received ratings of effective or better from the district on their last 3 performance evaluations. Now, this does not apply to Catholic schools. It could, but it doesn't have to, because you are at will. And in both cases, they can non-renew you, they can terminate you without cause, so to speak. And non-renewal is just cause, meaning there has to be a reason for the non-renewal. And once again, the reason could be that the number of students in art wasn't enough to support a teacher, and so therefore we had to lay that person off. We had to non-renew them. Okay. Terminating a contract with misbehavior may result at any time. It could result for a probationary teacher, could result for a tenured teacher. In other words, Michigan's Teachers Tenure Act requires all teachers to serve an initial 4-year probationary period before acquiring tenure, unless that teacher has previously acquired tenure in another Michigan public school district. In that case, they only need to serve a 2-year probationary period. I found this to be quite interesting because in Ohio, we have limited contracts. You folks don't have limited contracts. In Ohio, the teacher is typically hired initially on a 1-year limited contract. And if they do well, then they're given typically a 2-year limited contract. And if they do well again, they then get perhaps a 4-year limited contract. And at some point in time, they will then qualify for for tenure. So once again, it's state dictated. Okay, so now we're going to get into termination. And you should recognize that there are certain situations in which an employee could find themselves terminated, whether they're on a probationary status or a tenured status, and that is gross insubordination. So the principal tells the teacher, gives them a directive, do your lesson plan. And this would be a very good one. They do an official reprimand of this teacher because they've not been doing their lesson plans and submitting them as required. Now, the first time, once again, I wouldn't take official reprimand situations on that out of the gate. Make it 3 or 4 times before you take an official reprimand for that. So they continue. In fact, they tell you, I'm not doing them. They're a bunch of garbage. I write them and I have to change them, blah, 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 blah. But our handbook says you must submit weekly lesson plans. So now they have risen to the level of gross insubordination because they're in your face that they're not doing this. Okay? So that's gross insubordination. Then there's gross incompetence. This is really, really hard to pin on a teacher because once again, gross incompetence. So they don't know, they teach history and they aren't real sure of the dates for the Civil War. Oh, that's incompetence, I would think. Okay. Now, is that going to mean that we'll terminate them? Probably not. Okay. In the meantime, we're probably going to give them some remediation. We're going to suggest that they school up on those dates and those situations. But once again, gross. It has to be extremely incompetent for them to be considered for termination. I'm not sure that happens too often. The other one is neglect of duty. And the next lesson gets into tort liability. And of course, neglect of duty means that they are neglecting their tasks. Okay. And once again, if they neglect it once, I don't think you take action, but they continue, you warn them, you officially reprimand them, and they continue to neglect supervising their students in an appropriate manner, well, you might find them being terminated. So just understand that those are the kinds of situations that warrant a termination. Okay. Understand the importance of establishing a nexus between a teacher's conduct off campus and job performance to establish discipline tactics. This one here gets a little bit dicey. Okay. First of all, we want to make sure you understand the word nexus. And I really like to use the Erb case to explain nexus. Erb, I think he was in Iowa. He had an affair with someone and it became known, and the state board of education took his license from him. The school board said he's a good teacher. We don't want to lose him. And in the meantime, this affair is not affecting student attitude toward him. It is not affecting his job performance. There's no nexus between what was done and removing his license. And he did, in fact, get his license back. Now, if, for example, someone is having an affair, and in the meantime, the kids are talking about it, it's all over the school, yada, 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 isn't it terrible? Blah, 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 blah. I can't believe it. This happened. That could reach a nexus because it affects the confidence that the students have in that teacher and the management has in that teacher. So in one case, in this particular case, it didn't reach that level. And so whenever you're dealing with off-campus stuff, you have to concern yourself about nexus. Okay. Ohio has this very specific code that if you're out drunk and somebody reports you, the state is going to send an investigator and they're going to decide, they're going to decide what to do. It's pretty much out of the school district's hands. And they might decide to recommend termination. And so anyway, just be aware that off-campus activity, misbehavior in general, if there's a connection between that misbehavior and job performance, the person could be terminated. Okay. Let's talk about Loudermill versus Cleveland Board of Education. And I still, to this day, I think I mentioned this last week, I can't believe that Essex didn't include this in the text because it is major, major. And of course, the legal issue is due process upon termination action. That's the legal issue. The legal question is, can a state remove a civil servant's property rights to employment before providing an opportunity for that worker to respond to the charges? Due process. And of course, you might recall that Loudermill lied on his application that he'd never been convicted of a felony. And then they discovered, and he was a security guard. And then the board found out about it and they immediately fired him without due process. Goes all the way through the district court, appeals court, to the US Supreme Court. And they said, not so fast, Board of Education, you can't do that. And that established a procedural due process rights for teachers. And as I think I mentioned in the past, I can still recall the school attorney, when we were dealing with a staff disciplinary issue that raised to the level of the superintendent, I can still hear my attorney whispering in my ear, don't forget Loudermill. And by the way, just like I just shared with you, that you should, as a principal, you should feel comfortable in talking to your supervisor about a possible legal issue. Well, whenever I had a situation that was going to rise to the level of some sort of disciplinary action, which could be including termination, the first call I made before I talked to anybody was to the attorney. And he walked me through. And in fact, he would make me send him the letter that I am going to provide that teacher. And basically what we were saying is we were investigating whatever it was we were investigating. And you are off work with pay until this is resolved. Okay. So a very big case, Loudermill. They're required to provide written notice, fair and meaningful, unbiased hearing before an impartial tribunal, explanation of the proposed adverse employment action, job actions. They get a chance to respond to those charges. They get an opportunity to be represented by counsel, and they may appeal that termination in the court of jurisdiction. Now, in this case, because it would be a teacher contract, well, I'll ask you this. If it's a teacher contract and you're thinking about job action, would this go into the state courts or the federal courts? You might need to provide an explanation. It could probably go in either. If it's just a straight something to do with gross incompetence, we have got all the files and all the information. We officially reprimanded him twice and blah, 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 blah. This could go to the state courts. However, if it's a issue that is a federal issue, free speech, for example, then it's going to go to the district courts. But in general, these go to the state courts in general. Okay. So understand the legal aspects of teacher evaluation in Michigan. Can anyone tell me some of the specifics of evaluator teacher evaluation?
They have to rate each teacher effective developing or needing support based on the evaluation.
Yes, okay, that's good.
You also have to have 2 observations in the year.
Yep. And you have to have 30 minutes. Feedback from observations must be provided within 30 days and in writing. 20% of overall evaluations must be based on student growth. This was kind of interesting to me because it's not this way in Ohio. Educator evaluation is now subject to collective bargaining. So could be subject to collective bargaining. And what that means is, for example, if you're bargaining evaluations and the state law says that you have to have 2 observations, but you have to bargain this. And as a bargaining unit, the teachers want 3 observations instead of 2. And they get that into the contract. It supersedes the law, which is okay. It's as long as it supersedes the law, it'll be okay. Now, Carissa, you knew this. Is this the way your Catholic school functions with evaluation or not?
I hate to say it, but no, I know that I get at least 1 observation a year.
Yeah. And once again, you're not tied to that law. Now, I've often told Catholic school students this, I think that it would be wise to follow this state law because it's reasonable. It's very reasonable. And the last thing you'd want, if I was never a Catholic school administrator, but the last thing I'd want is I would not want to be charged with capricious activity with an evaluation. And so therefore, if I followed this law, I would be less likely, in my opinion, to be charged with capriciousness regarding those evaluations. But, once again, unfortunately, you don't have any recourse as a Catholic school individual. You have no recourse. So look at that. Okay. The next one is define progressive discipline. What's progressive discipline? Ezra?
That would be where you're going from the verbal kind of warning to another, depending on the instance, what kind of warning, a formal reprimand letter, and then to eventually, suspension without pay, termination, like that progressive, that we looked at in module 3.
Exactly. And you hit that oral warning. And once again, oral warning just means that you tell the individual you're late. Please correct this. Written warning is you put it in writing. Understand that with a written warning does not go in the student's or the teacher's file. Official reprimand goes in the file. It's more strict and due process protections are stricter for the official reprimand. And even though fines are listed, I don't know too many school districts that use fines for reprimand, but it's listed as a progressive step. Suspensions, non-renewal, and then termination. Okay. Okay. Questions on that? What surprised you the most about this module? What surprised you the most?
I guess for me as an educator at a Catholic school, it was learning about, I guess, how much that Catholic schools don't have to do in terms of evaluations. Now we partner with a public school district, so I am evaluated 2 times a year. I have to include student growth measurements. But the idea that, as an at-will employee, I can just be sent away. And that to me was, I knew that, but it was surprising to learn all like the protections that you may have as a public school educator compared to working in a private institution.
Yes. Okay. The walls, Either one of the Noels, what surprised you about this module?
Well, for me, like he said, coming from a private school, that's something that we dealt with where we're at will and really
No
you don't,
protection.
yeah, you're not protected, you're not, no job security. With this, looking at this, I just, even when they say termination, even with termination, you can go to the union and you can get represented and then they can fight for you.
Yes,
Way fix it, because we had an issue where something similar to that happened with one of the schools, and then they just told her, okay, leave at the end of the year, where it wasn't, and it wasn't even on her. I guess the way the union did it, where it didn't like it didn't affect her
yeah,
for the future for her jobs. They helped her that way, but she still had to leave on her own.
yes. So you can see where A, the union becomes a player, and B, documentation becomes legal, which is all important. Okay. Lenise, what surprised you about this?
Kind of like what Ezra was saying, like the at will part.
In your organization, you're at will, aren't you?
I am at will, yeah.
Yeah.
So you asked about the union. So no, we're not in the union. It's
Yeah.
nonprofit.
Yeah.
It's at will.
And by the way, I don't want to stir the pot,
Mhm.
but your organization, like any other organization in Michigan, has the opportunity to vote in a union.
Oh.
Oh, yeah. Oh, yeah. That's always surprising, I think, for individuals to hear. And I don't want to stir the pot,
Oh.
but and there's a procedure it has to follow in order to do that.
Mhm.
Probably in one of the Michigan laws that would lay out the specific procedures to do that, to get that vote. Okay.
Okay, that's good to know.
Okay. Carissa?
I hate to jump on the bandwagon. I mean, I'm in the same boat as Ezra though. And honestly, last year we didn't even have a teacher evaluation by my own administration.
Ouch.
We-
Ouch.
You're right. And what we did though,
Let me stop you there for a minute. Okay.
sure, of course.
So you're an at-will employee
Yes, sir.
and they don't do an evaluation.
They didn't, so
Well,
they didn't,
let me
they
finish.
didn't do one last year, but I will say that as with Ezra, we are also paired up with a local school district, and their organization, their school district, brought someone out 2 times a year, and we had to do student growth data as well, and put everything together with the Danielson lesson plan and all of that. So they were doing it through there, but my own administration hasn't. I think it's been like 2 years since she's come in.
So
Yeah.
once again, I'm not trying to stir the pot, but I want to put this in legal terms. So let's say that you have no evaluation by your employer,
Yes.
the diocese, okay? And you get asked to leave.
Mhm.
In my opinion, now I would advise people to go talk to an attorney, but I would think that they might have a fairly good case in the circuit court in Michigan. And I think my opinion was that person would win. So although you have no protections necessarily, you do not have to give up your rights to going through the court system. A person would not have to do that. So anyway, like I said, I don't want to stir the pot, but we want to bring that up. E, anything you have to add there?
Kind of like what everybody else mentioned about the at will part and not being protected.
Okay. Okay. So now we're going to turn to module 7. And module 7 is about tort liability. And my guess is this, I'll put it this way. For all my previous students, this one hits them in the head the hardest of many of the other aspects, because if they are found to be negligent, they could find themselves in court and could be even personally liable. Okay, so it's very important that you understand these terms. Okay, with regard to torts, there are two types of torts. There's intentional tort and unintentional tort. The intentional tort is just that. The wrongdoings are intended harm. Could be malice, could be assault, could be battery, could be emotional and physical abuse, could be libel, could be sexual abuse, could be slander. Those are all intentional torts, meaning the individual is intending to cause a person harm, whether that be a teacher or whether that be a student, doesn't matter, okay? As opposed to unintentional tort. And by the way, I saw that many of you have not started this particular one yet. So I'm going to kind of take over this a little bit more to give you a little bit, to provide the information that you're going to need. So unintentional torts are wrongdoings without intent, such as negligence. Negligence could be unintended. We just forgot to do something, and somebody got hurt, okay? Then there's the Good Samaritan law. And that means that a person is held without liability if he or she acted as a prudent person would act in the same situation. I would often advise teachers that if you're on the playground and a student gets hurt, well, if you've had first aid courses before, definitely provide first aid immediately. Don't go running to somebody else, have somebody else do that for you. Do it yourself. Even if you haven't had first aid, try to give them support. The Good Samaritan law will protect you. And that's what you need to know about the Good Samaritan law. Tort liability, that is when a victim is harmed or suffers damages, physical or emotional, and the victim can pursue a claim in civil court. That'd be state court, primarily be state court, under the state's tort laws. If the court finds a defendant liable or accountable under tort liability laws, the defendant is required to compensate the victim. Now, two things I want to let you know. The first thing I want you to know is that most school districts have $1 million liability policy for all their employees. And so therefore, you're negligent, you get into some hot water, oftentimes the school district is going to support you. So it's not necessarily going to be on you, so to speak. The other thing that I would say is that oftentimes unions particularly will encourage you to buy extra insurance. I don't know if I do that because you have this $1 million. Well, first of all, I checked to make sure that we had that policy in existence at my school. And most public schools have that. I don't know about Catholic schools, okay? So negligence is the failure to exercise the care that is what a reasonably prudent person would do in a similar circumstance, okay? And if it rises to that level, you probably will not be found accountable under negligence. There are the next one is to comprehend the elements of negligence, establishing that a person acted as a reasonable, prudent person, and the defenses against negligence. So with the elements of negligence there's a duty of care. For example, if a teacher is required to supervise their class and they aren't doing that, and some kid gets hurt, they actually have been negligent in their duty of care, okay? There's a breach of the duty, meaning that somebody gets hurt, okay? There's causation, something caused it to happen. And bottom line is there has to be injury. So you don't have negligence if there is no injury. Okay, so those are the elements of negligence. The defenses are these. So person finds themselves being questioned about negligent activities. The first one is assumption of risk. An assumption of risk, there's the doctrine that a person may in advance get hurt. Football is a good example of assumption. There's an assumption of risk when an individual participates in football. Okay. The next one is comparative negligence. In this, the defense is that they're looking at the individual that got hurt and the person who is responsible or considered to be negligent. And they're going to weigh how much one person plays on the other one. The next is contributory negligence. And this defense is when there's a contributing factor in the injury. And I always like to use this example to explain this. So the school district, the school, has a gymnasium. And during the times when phys ed's not in there, they don't lock the gym. And a student is messing around, goes in there, and he and his buddy are kicking a soccer ball, and the soccer ball gets stuck in the rafters, we'll say. And the student decides to climb up and get it down and gets hurt. Breaks their neck. Wow, that'd be really bad. Okay, so to start with, there'd be no assumption of a risk. Okay, there'd be comparative negligence because in one hand, the school should have had that gym locked so no one could enter it. But yet the student is at fault because obviously they decided to go in there unsupervised, climb up and get the ball and got hurt. So there would be an example of the defenses and how that would work. Another one that schools often use, particularly for field trips, is a hold harmless agreement. And a hold harmless agreement means just that if something happens on this field trip and somebody gets hurt, we're not going to be liable for that. Okay. And so I don't know if your schools have forms that you ask parents to sign off on when there's field trips or not, but that's considered a hold harmless agreement. Another defense that's often used is immunity. And so we need to recognize the different types of immunity. Immunity meaning we're not responsible, okay? And there's about 3 different levels of immunity. The first one is absolute immunity. And with absolute immunity, typically means elected officials. You know, you probably have heard maybe that the ambassador from a nation is in the United States and they commit a crime. Typically, they're going to be immune. Typically, they're going to be immune, okay? Then there's sovereign immunity. And in this, where there's no case against the state or its officials, they're just automatically immune. But it's different than absolute immunity. Then there's qualified immunity. And qualified immunity is based on a person's position. A teacher may point out concerns about a student. If valid, they would have qualified immunity. Where I see this happening occasionally is in the teacher's lounge. Teachers will be talking about a student, how bad the student is, yada, yada, yada. And somebody finds out, a parent finds out about it, and more than likely, they would be considered immune. They'd have qualified immunity, particularly if they're talking about academics. Now, if they're talking about drugs and things like that, that gets a little bit dicey. So anyway, that's qualified immunity. Probably of this particular lesson, the one that's the most important for you is child abuse laws, Michigan's child abuse laws. And that includes immunity and penalties for not reporting, as well as the teacher's responsibility to report suspected child abuse. And that's what teachers always need to know, educators always need to know. It's suspected child abuse. We're not making a judgment whether it is or isn't. The child comes to school and they're dirty, and it appears that they haven't eaten in a while. And obviously we're dealing with suspected child abuse here. And of course, teachers are mandatory reporters, along with other health professionals, clergy, et cetera, and what if you're guilty of not reporting, you could be in for imprisonment for not more than 93 days and have a fine of not more than $500. Here's what I always advise my staff. I always advise my staff and my principals that if you suspect if you suspect child abuse, report it. Report it. You protect yourself if you report it, even if it's not considered child abuse. Now, sadly, I didn't have a lot of good situations with Children's Protective Services. They tended to do things like this. They told the parents who reported it, which they aren't supposed to do. They would then make judgments that didn't support actions and some of those kinds of things. So it's very important that you understand, if you suspect child abuse, report it to Children's Services or the police. Report it. Then you've done your job. Okay. So the next one is the different forms of child abuse and neglect. And many of these you'll probably know. So what is child abuse? What's child abuse?
It's a negligence that could be caused by a parent or a guardian or a caretaker. It results in death or physical or emotional harm, sexual abuse, exploitation, any of those things.
Yes, physical mistreatment or sexual molestation of a child. Okay, that is as opposed to child neglect. And in child neglect is the failure of the child's caregiver to meet the child's physical, emotional, educational, and medical needs. Okay, so neglect. And so if we get back to our other terms, the first one would be considered intentional. This individual is intending to harm this person, as opposed to if it's neglect, it might not be intentional. Emotional abuse. What,
It's
go ahead.
distress, anguish, intimidation, things that are non-physical.
Yeah, emotional.
Mhm.
Maybe they're hypercritical of their child. Maybe they're embarrassing them. Maybe they shame them. Maybe they blame them or manipulate them in some way or shape or form, as opposed to physical abuse, which is pretty explainable, obviously, physical mistreatment. And of course, sexual abuse is very easily understood. So those are the general terms for abuse. There are three terms, at least three terms I want to make sure you hear and you know. The first one is called foreseeability. And foreseeability is a concept in neglect that refers to whether a person could or should have reasonably anticipated harm resulting from actions. Foreseeability. One of the things I required my principals to do is I required, and actually my superintendent required me to do it, is I required my principals to walk the building to see if there were any things that were foreseeable that we should avoid. The one that really sticks into my head, actually, we were doing a walkthrough with my Board of Education, and we're in the boys' gym, and I see a pencil sharpener. First of all, why is there a pencil sharpener in the boys' locker room? I have no clue, but there was, and it was broken off. And so therefore there was a sharp end to that. Now, can you imagine in a locker room with kids being kids, having that's foreseeable. You're asking for trouble there. So what did I do? The minute that I discovered, within a short period of time after discovering it, I got to the custodian. I said, get that thing off of there. That's got to be off of there. The other one that sticks to my mind is this was actually outside, and there was a plate. I can't remember if it was a plate for a sewer or what, but it was off. There was a gap between, and kids walked and got on the bus kind of over that situation. Well, that's foreseeability. We made sure we corrected that right away. The next term that we want to make sure you understand is deliberate indifference. Deliberate indifference. And deliberate indifference occurs when a school administrator professional knows of an act against a person and completely disregards the alleged behavior. You're going to find out about this term when you start to get into student rights, because there was a young girl who was being sexually abused by a teacher, and the school administration knew about it, did nothing about it. The court went to federal, the case went to federal case, and ultimately the parents and the child were awarded relief financially for this. And what was classified, it was classified as deliberate indifference. That's why one of the things I, once again, advise potential administrators is, I know you hear all kinds of things about bullying and cyberbullying and lots of that crap. Well, unfortunately, you don't want to dismiss it. You at least want to ask some questions, because there are cases, and one in Ohio, where the school system didn't do anything. Girl was being abused emotionally. She killed herself. The parents didn't want to do it, but they went to court, and it was deemed that, oh my God, the school administration knew this and did nothing. And then sometimes you have to, the level of what you do depends on the situation, okay? The last term that I want to bring up, and then I'll give you a chance to maybe ask some others, is defamation of character. And this gets a little bit confusing sometimes, because there are two types of defamation. The first one is slander. And typically, well, slander means written defamation. So somebody's out there on Facebook and defaming you as a teacher. Do you have a case for defamation? Maybe. Once again, I wouldn't just leap out there and take any action. I would start documenting, and then I would go to an attorney, and we would go from there, okay? And sadly, this happens way too often in schools, as I'm sure you're aware. And the next one is libel, and that means spoken defamation. And of course, the definition, there's a legal definition of what rises to the level of defamation, okay? Are there other terms that you would like to have me explain? I know that in tort liability, there's probably lots of terms that were unfamiliar to you, but I did want to make sure that you were aware of foreseeability, because it's very important, defamation, and deliberate indifference. Okay. Carissa, would you stay around for a second? Okay. And see you guys later. Good luck on your quiz. Make sure you take time with that that tort liability unit, modular, okay? And understand the terms. Make sure you are well aware of those terms because those terms become very important, okay? With that, we shall see you later. Oh, and yeah, I told you about the bonus reference letter, okay?
Dr. Bourne, could I actually stay for just a moment since I have the parent-teacher conferences? Is that okay? Or do you want me to schedule another time?
Well, see, how can we do that? I want to talk to Carissa. Let's do this. Is your issue private?
Mine?
Yes.
Oh, no, I had missed the beginning when we talked about the bonus assignment.
Oh,
Can
yeah.
I can schedule another time though. That's totally.
No, this is fine. So, what I was saying is that, I always have a